As promised, day one, President Donald Trump, by executive order, ends birthright citizenship. The question is, can he really do it? Hello, everyone. This is Andre McKinney Dorval, a licensed immigration attorney. I am located in Florida. In this video, we're going to take a look at the executive order signed by President Donald Trump, which seeks to end birthright citizenship. We're also going to take a look at case law that settled this question over 100 years ago. And lastly, we're going to look at the lawsuit filed by the ACLU on yesterday challenging this executive order. I'm now going to share my screen. On screen, guys, we have here the executive order in question entitled Protecting the Meaning and Value of American Citizenship. Section 1 of this executive order reads, "The privilege of United States citizenship is a priceless and profound gift." The 14th Amendment states, "All persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside." That provision rightly repudiated the Supreme Court of the United States' shameful decision in Dred Scott versus Stanford, which misinterpreted the Constitution as permanently excluding people of African descent from eligibility from the United States citizenship solely based on their race. It goes on to say, but the 14th Amendment has never been interpreted to extend citizenship universally to everyone born within the United States. The 14th Amendment has always excluded from birthright citizenship persons who were born in the United States, but not subject to the jurisdiction thereof. Consistent with this understanding, the Congress has further specified through legislation that a person born in the United States and subject to the jurisdiction thereof is a national and citizen of the United States at birth, 8 U.S.C. 1401, generally mirroring the 14th Amendment's text. Now, the executive order goes on to read, among the categories of individuals born in the United States and not subject to the jurisdiction thereof, the privilege of the United States citizenship does not automatically extend to the persons born in the U.S., 1, when that person's mother was unlawfully present in the United States and the father was not a citizen or a lawful permanent resident at the time of said person's birth, or 2, when that person's mother's presence in the United States at the time of said person's birth was lawful but temporary, such as, but not limited to, visiting the United States under the auspices of the Visa Waiver Program, or visiting on a student, work, or tourist visa, and the father was not a U.S. citizen or lawful permanent resident at the time of said person's birth. Section 2 of the executive order reads, policy. It is the policy of the United States that no department or agency of the United States government shall issue documents recognizing United States citizenship or accept documents issued by state, local, or other governments or authorities purporting to recognize United States citizenship to persons, 1, when that person's mother was unlawfully present in the United States and that person's father was not a United States citizen or lawful permanent resident at the time of said person's birth, or 2, when that person's mother's presence in the United States was lawful but temporary, and the person's father was not a United States citizen or lawful permanent resident at the time of said person's birth. Subsection B states, subsection A of this section shall apply only to persons who are born within the United States after 30 days from the date of this order. So guys, this section here answers the question, when is this going to go into effect? And by its terms, this will go into effect 30 days from the date of the order. This order is dated January 20th. Let's move on to subsection C, goes on to state, nothing in this order shall be construed to affect the entitlement of other individuals, including children of lawful permanent residents, to obtain documentation of their United States citizenship. Now, the enforcement. It reads, the Secretary of State, the Attorney General, the Secretary of Homeland Security, and the Commissioner of Social Security shall take all appropriate measures to ensure that the regulations and policies of their respective departments and agencies are consistent with this order, and that no officers, employees, or agents of their respective departments and agencies act or forbear from acting in any manner inconsistent with this order. It goes on to read, the heads of all executive departments and agencies shall issue public guidance within 30 days of the date of this order regarding this order's implementation with respect to their operations and activities. So guys, we can expect that within 30 days, guidelines are going to be issued. They're going to be written and issued as to the implementation. Let's move on and take a look at the case that I mentioned that answered this question over 100 years ago, and that is the Supreme Court case of United States versus Wong Kim Ark. Now, just a little bit of context of this case. This is a picture of Mr. Wong Kim Ark, excuse me. Now, Mr. Wong Kim Ark was born in the United States to Chinese parents, though he frequently returned to China on a temporary visit. When attempting to return to the United States in 1890, Wong Kim Ark was barred from entering the country under the Chinese Exclusion Act. That act has since been repealed because under the law, Wong Kim Ark could be excluded from the United States based on his Chinese ancestry. Now remember, this states Mr. Ark, he was born in the U.S. His parents were Chinese parents. Now, this is a landmark case that stands for the proposition and established that any person born in the United States is a citizen by birth. That's what this case stands for. Let's move down a little bit and see what the Supreme Court held. Now, the Supreme Court in a 6-2 decision stated that, Supreme Court held in a 6-2 decision that because Ark was born in the United States and his parents were not carrying on business or employed in any diplomatic or official capacity under the Emperor of China, implying that these would be the only reasons Ark might not have counted as subject to the jurisdiction of the United States. Ark was indeed a U.S. citizen. So the Supreme Court at that time found that he was in fact a U.S. citizen because his parents were not carrying on business or employed in any diplomatic or official capacity under the Emperor of China. Remember these exceptions because we're going to talk about them. Now, let's talk about briefly how can the 14th Amendment that establishes birthright, citizenship by birth, how can that legally be changed? Well, there are two recognized ways. And that is, one way is through an act of Congress. If the House or Senate, by a 2/3 vote, were to decide to begin the process to change the 14th Amendment, the House would have to have 290 out of the 435 votes. The Senate would have to have 67 out of the 100 votes. And then 3/4 of the states, which is 38 states, would have to approve that. So that's changing the Constitution, starting with Congress. The other way is by the U.S. Supreme Court. Now, we're now going to take a look at the lawsuit that has been filed by the ACLU. And so I'm going to scroll up so that we can take a look at who are the parties to this lawsuit before we dive into what the lawsuit says. And guys, thank you for hanging in there with me. I know it's a lot of information, but the people perish for lack of knowledge. So we've got to be knowledgeable about the law in order to understand what the implications of all of this means. So this lawsuit was filed yesterday in the District Court of New Hampshire, and the plaintiffs are New Hampshire Indonesian Community Support, League of United Latin American Citizens, and Make the Road New York. The defendants are Donald J. Trump, President of the United States, in his official capacity, the U.S. Department of Homeland Security, Secretary of Homeland Security, U.S. Department of State, Secretary of State, U.S. Department of Agriculture, Secretary of Agriculture, Centers for Medicare and Medicaid Services, Administrator of the Centers for Medicare and Medicaid Services. These are the defendants. Guys, I've already highlighted the sections of this complaint I want you to be aware of. It is 17 pages. And so let's scroll down to paragraph 34, and let's take a look at that. So paragraph 34, let's start with 33. And now in paragraph 33, remember we just looked at that case, U.S. versus Wong Kim Ark. And so this complaint cites to this landmark case that says citizenship by birth within the territory is fundamental. The Ark case told us that. And then it goes on to paragraph 34, and it describes in the infamous case of Dred Scott versus Sanford, the Supreme Court held that despite their birth in the United States, the descendants of enslaved people were not included and were not intended to be included under the word citizens in the Constitution. Paragraph 35 goes on. After the Civil War, Congress repudiated Dred Scott and constitutionalized the birthright citizenship rule in the 14th Amendment's Citizenship Clause. So remember when I said, how are the two ways that the 14th Amendment could be changed legally? The one way is through Congress. So after the Civil War in the U.S., Congress, by passing the 14th Amendment, in effect, did away with the Supreme Court decision in Dred Scott. And so from the 14th Amendment on forward, birthright citizenship has been the law of this land. All persons born, as this complaint says, all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the U.S. Let's continue on. Paragraph 38 of the complaint says, the only exception that's relevant today is the children of foreign diplomats who under Wong Kim Ark are not subject to the jurisdiction of the United States. And then moving on to paragraph 39, another exception here is that children born to foreign armies living in U.S. territory that those armies had conquered, and the complaint says there is no such U.S. territory today. Okay, and we're going to move on a little bit further down, to who are the plaintiffs in this case and their members. So the plaintiffs are the organizations that I mentioned earlier in this document: NHICS, MRNY, LULAC, their abbreviations, which are membership-based organizations. Each organization has members who are living in the United States and currently expecting children who, once they are born, will be denied citizenship under the executive order. Now, moving on, paragraph 52. Such individuals who will be affected by that executive order are described in paragraph 2 of the complaint, and that is, for example, Gail and Thomas, open air quotes, are NHICS members whose child, when born, would be denied U.S. citizenship under the order. It goes on to describe Gail came to the United States on a tourist visa in 2023 and has a pending application for asylum, but no other current immigration status. She is pregnant and has a due date in late February. The complaint goes on to say Thomas is Gail's husband. He came to the United States in 2023 on a tourist visa. and has a pending application for asylum but no other immigration status. He is the father of Gail's expected child. So Gail and Thomas, a married couple who came on a tourist visa in 2023. So now they no longer, that tourist visa is expired. So they've been here. They're not in that, non-immigrant visa status. And so they're now pregnant. Gail and Thomas are people that would be affected by the executive order. Let's continue down a bit further into this complaint. And so in this section of the complaint, it talks about the impact of this executive order on plaintiffs, their members like Gail and Thomas, and other families. It goes on to say some of the impacts would include creating a subclass of children who were born in the United States but lacked fundamental legal recognition and face stigma as a result of their novel and uncertain status. Moving on to paragraph 64, it says, by attacking the principle that all children born in this country are citizens, the order will invite persistent questioning of the citizenship of children of immigrants, particularly children of color. Other impacts will include, once deemed to be non-citizens, the children of plaintiffs, members, and other similarly situated children will be subject to immigration enforcement by DHS, Custom and Border Patrol, CBP, and ICE. This may include arrest, detention, and deportation to countries they have never visited. It further goes on to say improperly threatening children with arrest, detention, and deportation and forcing them to grow up in fear of immigration enforcement imposes harms on those children and their parents. Now, we're going to move on a little bit further and discuss what is this lawsuit asking the court to do? What is the prayer for relief? What are they asking the federal judge to do in this case? And in this case, it's quite simple. ACLU is asking that the court declare that the executive order is unconstitutional and unlawful in its entirety. Secondly, to preliminarily and permanently enjoin, which means to prevent, to stop the defendants from enforcing this executive order. Now, guys, where do we go from here? Now that the executive order has been signed, ACLU has filed a complaint on the very same day. Well, the next steps are the following. The defendants, they will file a response and an answer. Now, as we've just seen, the ACLU wants the court to enter a preliminary injunction. That means a preliminary order saying nothing happens until this question is settled, until this lawsuit is settled. And the reason why that's important, guys, is because there are many people in Gail and Thomas's situation that are currently expecting their child, which their due dates are slated to be after 30 days when this executive order goes into effect. And so they are directly affected because the complaint indicated they are expecting their child in late February. And so the second thing that we can expect is that this case will likely go all the way up to the Supreme Court. And so with that, it's unclear how long will that take. So it's going to be really important, guys, for the district court to enter a preliminary order putting a halt to this executive order that ends birthright citizenship until this case can make it as far up as the U.S. Supreme Court. Guys, this video was intended for informational purposes. I hope you found it very informative. I know it was a little bit long, but guys, I had to give you background information so you can understand how we got here and what is being challenged, and what the defendants are saying their position are. And so we will continue to keep you updated as this lawsuit evolves. I do want to thank you for watching this video. I also want to thank everyone who has subscribed to the channel. Your support is greatly appreciated. Once again, thank you for watching this video. Please, guys, like the video, share the video, and please subscribe to the channel. Thank you so much. I will see you in the next one. Bye-bye.